Hey folks, Professor Finn here, and welcome to your funeral law class. This lecture is going to talk about the structure of the U.S. legal system, intro to how kind of the court system works and the type of courts there are and stuff like that. So let's go ahead and get started. Without laws to regulate human behavior, human beings have a tendency to solve their problems in an uncivilized way. They may be fun, they may be creative, but they are certainly uncivilized. Law provides a guarantee that justice will be carried out according to rules established by federal and state courts by a well-qualified judiciary rather than individuals' feelings or biases. And while this sounds good in theory, it may not really reflect the idealistic nature of this presentation in practicality. Law can be defined as rules established and enforced by a government to regulate the conduct of individuals and groups in a society. And the American Board of Funeral Service Education defines law as those rules of conduct commanding what is right and prohibiting what is wrong. The rules that make up law are actually legal duties that are imposed on people and require them to act in certain ways. And when they do not, they violate the law. And the object of any legal rule is justice or fairness. Now, tomato, tomato, justice may not equate to fairness, but ideally, the object of any legal rule will be justice or fairness. No matter how good the laws of the system, there will always be disagreements with the jury verdicts, but if a system works good most of the time, then it is sufficient for use by society. Every time a law is created, a person's freedom to act in some way is restricted, and at the same time, trying to settle disputes without resorting to law will produce chaos. So it's always this antagonistic relationship. There are four functions of law. The first is to settle disputes. The second is for the protection of the individual and society as a whole. Those two things may not be aligned. Protection of property and promotion of worthwhile social objectives. Roman law and English common law are the two most important influences on law in the United States as we know it today. Prior to Roman times, most law was oral, and decisions were made by judges or juries with no written record, and decisions were passed on by word of mouth from generation to generation. The Romans developed written codes so that everyone could know and understand the laws that would guide almost every aspect of their life. Emperor Justinian codified and developed a significant portion of the Roman law, which later became known as the Justinian Code. Napoleon revised this many centuries later in 1804, and this became known as the Napoleonic Code or the Code Napoleon. Napoleonic Code is the basis of much of the law of Europe, as well as the laws of China, Japan, Mexico, some South American countries, and the state of Louisiana. Common law was developed in England in 1066. The English system of law is called common law. Common law refers to the body of legal decisions made by English court judges under the authority of the king over a period of many years. Unlike the Roman law, early common law was oral in nature, with English judges traveling to various communities in their locality to hold court and try cases. Each case produced a new oral law that served as a precedent, an example or standard for deciding subsequent cases involving the same or similar facts. This led to the creation of the doctrine of stare decisis. It is a Latin term which means to stand by a decision which was previously decided. The doctrine generally demands that a prior decision be followed, but it can be overturned if a new rule establishes there is a good reason to do so. Under Henry II in 1154, the common law was unified into a body of law. He incorporated local customs to the national level, which ended local enforcement of unwritten customs pertaining to criminal and civil matters. Laws were put into writing, arbitrary remedies were eliminated, and the jury system was sworn on oath to decide criminal and civil cases rather than using an informal group of community members. The English common law became the model for the legal system of the United States after its independence from England. Our primary sources of law in the United States are constitutions, statutes, administrative regulations, and court decisions. A constitution is the fundamental written law of a state or nation. It defines an individual's rights and duties and describes the government's structure and functions, its powers and limitations, and the relationship between the government and individual citizens. There are 51 constitutions in the United States, the Constitution for the federal government, and a constitution for each of the states. Constitutional law is the law stated in these constitutions. Most of the state constitutions are modeled after the federal version. The United States Constitution is the supreme law of the land and takes precedence over all state constitutions. No law, whether enacted by Congress or by a state legislature, may conflict with the basic principles of the U.S. Constitution. Constitutional law evolves primarily from judicial interpretation of the meaning of the Constitution as issues arise. Statutes, or legislation, are laws that appear in specific written form, having been formally passed by legislative bodies rather than stated in opinions by judges in court cases. At the federal level, legislation passed by Congress is called acts. At the same level, the same legislation passed by the legislatures of the 50 states are referred to as statutes. Legislation passed by local governments are called ordinances. The modern emphasis is on statutory law, especially in more specialized subfields that are complex. The laws that legislatures make can be sweeping and comprehensive and, if necessary, can be enacted rapidly. By contrast, courts can only deal with issues that arise in actual cases brought before them by individuals and businesses. The journey is often slow and issues are generally narrow in scope. Finally, changes in the law that result from court cases are usually small and limited to a specific situation. Although the modern emphasis is on statutory law, a substantial portion of U.S. law is created through decisions that judges and juries hand down in court cases, which is known as case law. These court decisions produce precedents that have the force of law, and other courts will follow these precedents when they decide similar cases in the future. The advantage of the doctrine of stare decisis is that with a precedent, people have a good idea of what the consequence will be as a result of their actions. Judges very seldom overrule previous precedents because the risk of a new opinion being overturned by a higher court is substantially increased. If there is no existing precedent, a judge's written opinion must contain a solid legal argument justifying the decision because it will likely become the standard precedent used for cases in the future. This is also a reason why, when a court decides something new and novel, it takes a very long time to see, is this the right way to do it? You will find that a decision is made, and judges are loath to overturn them for the first decade or so because they have to see how this is going to play out for the long term. It is impossible for legislatures to make all the necessary rules or for courts to handle all of the cases. As a result, most of the regulation that handles individuals and businesses in the United States today is done by administrative agencies at the federal, state, and local levels. These agencies have been delegated the power to make rules called administrative regulations, which have the same force and effect as statutes or court decisions. Agencies can take legal action against violators of their rules in much the same way the courts do. Federal agencies are created by Congress. State administrative agencies are created by state legislatures, and local administrative agencies are created by city councils or by town or village boards. Although administrative regulations have the same force and effect as statutes and court decisions, these rules can be challenged in the courts. A business or an individual may challenge them on the basis they are unconstitutional, vague, or beyond the power granted to that agency. Civil law establishes rules to protect the rights and property of individuals from harmful acts by other individuals. The person who was harmed because the other person violated civil law may initiate a civil action against the offender seeking compensation for the harm that was caused. Criminal law establishes rules to protect society from acts of individuals that are considered so dangerous that they threaten peace and order within a society. A person accused of committing a crime is subject to arrest and, if convicted, punishment. It is for this reason that in criminal cases, the government brings the proceeding against the accused individual. Although a person may be subject to a criminal prosecution for the commission of a crime by the state, the individual may also be the subject of a civil lawsuit brought by the victim of that same crime. Civil lawsuits are generally confined to just awarding money damages as relief to the injured party. When money damages are not suitable or adequate, the legal system recognizes the principle of equity or non-monetary relief. Equity grants relief in accordance with the principles considered to be fair and just. If money is inappropriate, specific performance of a task or an injunction to refrain from conduct would be an equitable solution. Some unethical behavior may be serious enough to be considered criminal in nature and therefore subject a violator to a fine or even incarceration. The behavior may be considered a civil matter and therefore subject the violator to litigation, resulting in the payment of monetary damages. Ethical violations, and especially those that amount to civil and criminal wrongs, may not always be evident to the employees of a company. Alternatively, employees may simply be unconcerned with their behavior. A code of ethics that clearly defines the type of behavior expected of employees and that makes reference to what is considered legal and ethical violations becomes a very important document for minimizing unacceptable behavior in the company. The United States has two separate and distinct court systems, the federal court system and the state court system. The federal or national court system is established by the U.S. Constitution and the U.S. Congress. The state or local court system is established in each state under state law. With courts located throughout the country, principally in the larger cities, the federal court system uniformly follows the same rules and procedures. State court systems differ from state to state in their names and their procedures, but a substantial majority try to emulate at least some of the rules of the federal system. State courts handle over 90% of all cases because most of the offenses that occur are violations of state rather than federal laws and fall outside the jurisdiction of the federal court system. Both systems, state and federal, have three lower courts with different types of jurisdiction. Trial courts, where a case begins. Intermediate courts, appellate courts, which review judicial decisions and jury verdicts from the trial courts. And courts of last resort, typically Supreme Courts, that have final authority in the cases they hear. The names of these courts are of little consequence or importance in comparison to the hierarchy. So for instance, in the state of New York, the New York Supreme Court is the initial trial court, whereas here in the state of Florida, the Florida Supreme Court is the court of last resort. Jurisdiction is the legal authority of a court to hear and decide the case. Trial courts have original jurisdiction because they try cases for the first time. If you look at the U.S. Constitution, you will see what types of cases the federal court system have original jurisdiction over. Appellate courts or court of appeals have appellate jurisdiction, which is the authority to review cases that have already been tried in the lower courts and then make decisions about these cases without holding a new trial. Appellate judges determine only whether errors of law are made in a trial. No new information regarding the actual case, such as facts or proof, is permitted. Appellate court judges may affirm the trial court decision, reverse it, or order a new trial. Further Further appeals in both federal and state courts are taken to the next level in courts of last resort. No court can decide every kind of case. Jurisdiction over subject matter means the court can hear and decide only certain types of cases. Some courts have general jurisdiction, while others have limited jurisdiction. Jurisdiction over the person means that a court can hear and decide a case because it has authority over the parties, the plaintiff and defendant, in a case. The party who brings the case automatically comes into that court's jurisdiction. The defending party is brought under the court's jurisdiction through a legal process that is a bit more complicated. Personal jurisdiction includes a person domiciled in a particular state and a non-resident temporarily present when a summons is served in that state to the non-resident. In a criminal case, an arrest made by means of an arrest warrant issued by a judge brings a person accused of a crime into court. While each state governs its own judicial system, generally each state will include the following: trial courts of limited jurisdiction, trial courts of general jurisdiction, intermediate appellate courts, and appellate courts of final resort. A state court decision is generally not binding on courts of other states. State courts have the authority to decide nearly every type of case subject only to the limitations of the U.S. Constitution, their own state constitutions, and state law. The federal court system is a bit more complex in how it is created. Article 3, Section 1 of the U.S. Constitution created the Supreme Court and gave Congress the power to create inferior federal courts and to determine their jurisdiction. Federal courts decide cases that involve the Constitution and federal laws enacted by Congress or the U.S. government. They also deal with cases for which state court jurisdiction is inappropriate. The U.S. Constitution provides that federal judges and justices of the Supreme Court be appointed for life terms. Appointments are made by the President and confirmed by the U.S. Senate. The U.S. Supreme Court is the highest court in the federal judiciary. Congress has established two levels of federal courts under the Supreme Court: the trial courts and appellate courts. There are also specialized courts with limited jurisdiction. The federal district courts are the trial courts of the federal court system. Each state has at least one district court, with more populous states with extra federal district courts. District courts hear cases under the general two categories of federal issues and diversity of citizenship. Federal issues are those issues or arguments that pertain to federal law passed by Congress, as well as that which pertain to the U.S. Constitution. Diversity of citizenship applies to citizens of different states that are involved in a lawsuit based on state laws. There are restrictions to bring a case by diversity, and your book referenced it, the $75,000 minimum amount, as one of the factors. The United States and the District of Columbia are divided into 12 circuits, with each circuit having a single court of appeal. There is a 13th court of appeal that has nationwide jurisdiction over cases that relate to copyright, trademark, and patent issues. Neither the Federal Appeals Court nor the U.S. District Courts have jurisdiction to review decisions of the highest state courts. The Supreme Court of the United States is the highest court in the federal court system and the highest court in the land. It is the only court created by the Constitution. Once the Supreme Court rules on constitutional issues, the judgment is virtually final. The Supreme Court is usually unlikely to turn over one of their own decisions without extremely good reasons. The U.S. system of government and law is based upon the concept of separation of powers. The U.S. Constitution establishes three distinct and independent branches of the federal government: legislative, executive, and judicial. The legislative branch, or Congress, consists of the United States Senate and the House of Representatives. The legislative branch makes much of the laws of the United States. The executive branch, the President, is responsible for enforcing the law. And the Judiciary, Supreme Court, and other federal lower courts interpret the law. Our system was created to prevent any one branch from obtaining more power than another branch and from gaining absolute control of the government. The concept of separation of powers is not always followed. Courts can make law by interpreting existing law, and that interpretation may change a lot in the same manner that a legislature might change the law. Courts also make decisions that are often political in nature. These acts are incidental. For the most part, our judicial system concentrates on interpreting laws. A distinct characteristic of our legal system is that it combines statute, laws enacted by legislatures, with decisions made by courts. Another important principle of our legal system is that of constitutionality. The U.S. Constitution is the supreme law of the land, and each state's constitution is the supreme law in that state. State statutes, governmental actions, and court decisions may be declared invalid if they violate the principles of either the state or the federal constitution. Judicial review gives higher courts the power to review decisions of a lower court and rule on their constitutionality. Federal courts can review acts of the U.S. Congress and state legislatures, and the U.S. Supreme Court can review decisions of the highest state courts. The review process allows decisions and laws to be reversed or changed if they are not in harmony with existing laws and constitutions. The Supreme Court case of Marbury versus Madison established the basis for the concept of judicial review by declaring an act of Congress unconstitutional. Roe versus Wade struck down a Texas statute that made performing an abortion a crime, which shows the influence of the Supreme Court on state matters. This concludes the lecture on the introduction to the U.S. legal system.